Good morning, Ms. Flatela.
Good morning, Deputy Chief Justice.
How are you?
I am well, thank you, DCJ. How are you?
I'm fine, thanks. Are you comfortable?
Yes.
All right.
I'm a bit nervous.
Perhaps I should declare that I've known you since you were a young girl, and I'm shocked to see that you are graying. And
I am great.
What does that say about me? In fact, I was shocked when I looked at your application form and I saw that you have a 17-year-old, because to me you remain that young. You are the 17-year-old. Okay. You hold a BProc degree from the University of Transkei.
Indeed, DCJ.
Mm-hmm. And after you had obtained that degree, you went on to do a master's degree specializing in commercial law with UNISA.
Yes, DCJ, that's true.
How did you find that experience, studying on your own?
I enrolled for the LLM when I was doing the. I think I was a PA at Bemen Cats Attorneys. So there was a lot of time, and they allowed me to study.
All right.
Yes. And
at some stage later, you did a course in a diploma in alternative dispute resolution with UP.
Yes, DCJ, that's true.
Right. Just tell us a bit about your legal career. What have you done? Where have you been that brought you here?
Yes, I started my legal career as a candidate attorney with the firm Bemen Cats Attorneys in Port Elizabeth. It was a firm that specialized in property law and property rights law. After admitted as an attorney, I was there for a year. Thereafter, I went home, back to Mthatha. And fortunately, when I was in Mthatha, there was a position that was available, that of a legal research assistant for judges in Mthatha High Court. Although I was already admitted as an attorney, I availed myself for that position because early in my career, I decided that I would like to be a judge one day. And then when that opportunity came, I did not hesitate to avail myself for that position. So I was there for 3 years as a research assistant for judges. After that, I was then employed by the Department of Justice as a state attorney.
Yes.
I was placed in the property law department, where I dealt with all property law related litigation, starting from the restitution of rights, evictions, ESTA, PI applications. I also was a conveyancer responsible for transferring the government's properties from the Republic of South Africa to national government of the Republic of South Africa. So for 9 years, I dealt with the restitution of land rights. I practiced mainly in the land claims court and also in the High Court. Until from 2006 until 2015. 2015, I resigned. I had reached the ceiling for being in the state attorney. I established my own practice Flatela Attorneys Incorporated, where I also specialized in property matters, now representing the claimants. Whilst in the state attorney, I was representing the department and the Commission on Restitution of Land Rights. I was now in the panel where I represented the claimants, the farm dwellers, and labor tenants. So I dealt with all aspects of Esther. I also dealt with mainly my practices as it can be described as human rights, public interest law, although it was not an NPO, but I felt that spending much time in the state attorney, I needed to practice in my area of choice. I'm an activist, so the human rights law and especially the land law is very important to me. So I use that opportunity to practice as such.
Yeah. In your application form, in that part where you are asked to describe your contribution to the pursuit of justice, you say something that touched me deeply. And you speak of the social strife that you witnessed in many of the matters you handled dealing with land law. And you highlight that the most vulnerable in those matters were women, and often their children left destitute because there's no adequate protection for them under the law. And you go on. Is that what has caused you to apply for this job? Why do you seek this job?
Yes, I, very early in life, before I even enrolled for a BProc degree, I witnessed injustice. I was born in the village, but early in life I traveled a lot because my aunts were working in 2 different towns where you had to pass. For instance, my 2 aunts were working in Mzimkhulu. You had to pass Kokstad, that is, it was the Republic of South Africa, to reach Mzimkhulu. And when you every time we traveled to Mzimkhulu, we were stopped, searched, and my aunts had to produce the travel, the passport. And
it was called the travel document.
It was called the travel document then, and my name and my cousin's name were under my aunt's my aunt's name. And I was very inquisitive child. I was asking my aunt, why are we always stopped by the police, and why are we always searched? And those ones that were not political conscientized. So there was the other one that was working as a principal in Queenstown. Also in Queenstown, you had to, in Esbelin, to reach Esbelin, you had to pass Queenstown.
There was a border there.
Yes, so there was always. So I witnessed this injustice at a very young age. So I asked, that aunt was very political conscientized, and she told me, and she told us about the history of land dispossession and conquest, and told us why we are searched, that we were not regarded as citizens in this country, and we were just given the places to stay, and whilst at the same time witnessed people from white group, they were moving freely. Even when we entertained ourselves, I'm born in the Wild Coast area. So during holidays, we would go to Mzamba and Port St. John's, but would see our fellow South African, the whites, moving with boats like they were enjoying, and there were segregation even then. There were parts of the ocean that we could not swim and all that. So then I was then told about the history. And with me, I grew up knowing that I have to be part of the people that are going to see to it that there is justice, there is equality, even if that meant I should go and join those who were fighting. So that is my background, and then I learned about law, that it can be used as an instrument to bring forth freedom to people. So I resolved that I would enroll for law and do law and use law as an instrument of revolution.
Yeah. You have acted as a judge in the High Court.
Yes, DCJ I have.
Where? In which divisions?
Yes, I was invited last year in the Eastern Cape Division by JP Mbenenge. For 6 weeks, I was in Mthatha. In the Eastern Cape Division, both in Mthatha and in Grahamstown.
And I see that you also acted in the South Gauteng High Court.
Yes, I acted in the Land Claims Court. So when you act in the Land Claims Court, you automatically act in the South Gauteng High Court and in the Gauteng Division. So both Johannesburg and Pretoria. So I was acting in the Land Claims Court and in the Gauteng Division.
So you are no stranger to the Land Claims Court?
No,
actually.
I'm not stranger at all.
Did you manage to produce judgments during your acting stint?
Yes, in the Land Claims Court, I did produce some judgments. Although I must say, I acted at the time when it was during COVID. So the matters that we really did, it's ESTA matters. The restitution matters were postponed until the issue of the pandemic was resolved. So I did produce some judgment in those matters. And also in the High Court, I acted in the High Court, I did produce some judgments.
Well, those judgments seem to have impressed the relevant people. The professional bodies, right, have sent very complimentary reviews on you, and they describe your judgments as progressive and many other, they use many other good words to describe them.
Yes.
Did you manage to produce them promptly?
Some, yes. Some, no.
What does that mean? Please explain. Do you delay judgments?
Yes, there was an issue with regards to my firm. I am a one-woman controlled. It's owned and controlled by me. During last year, my support staff were affected by contracted COVID. So I was struggling throughout the period of my acting stint with regards to the support, the secretaries and my intern. So especially during the fourth term, that's where the problem is. You see that there were many reserved judgments during that time. I had struggled with the support.
How long did it take you, on average, to deliver them?
I think 3 and others 4.5
Months?
to 5 months, yes.
Was it not possible to get help? Did you approach your judge president? Why could you not be given assistance if there was something the matter with your own staff?
During the, as I said, it was during the time of COVID.
COVID.
Yes, during the time of COVID, it was very difficult to communicate, but I had, Judge Mir will know, I had raised the issue with her. But I think I did not with Justice, with JP Mlambo. And I told him, I just was pushing, thinking that I would be able to do it, but it was just overwhelming. It was before me, and Gauteng is one of the busiest courts. But I had explained to him later, and he told me that I should have told him he should have arranged, and he should have gotten help for me.
Yeah. Well, you know better now.
Yes, I do.
All right. Thank you so much, Ms. Flatela. I will hand over to the commissioners to put questions to you if they have any. And may I just remind my fellow colleagues that it's strictly 2 questions. We go back to our ground rules now and we enforce them. We have many candidates for today. So no preambles, no observations, no statements of fact before we put the actual question. Let's just get to the question. Minister.
Judge Mir, disagree.
Sorry?
The president of the court is here.
Oh, my goodness. Thank you so much. Judge Mir?
Thank you. Good morning, Ms. Flatela.
Good morning, Judge
You have a
Mir.
long association with the Land Claims Court. We first got to know you when you litigated actively as a member of the State Attorney's Office.
Yes.
And more recently, of course, you acted.
Yes.
You acquitted yourself well as an acting judge, notwithstanding the difficult circumstances during which you were with us, which was during COVID. And as you rightly say, you dealt mostly with Esther matters. Now, as you know, our court is a circuit court. We travel all over the country, sometimes far-flung rural areas, to hear cases. Is there any reason why it is going to be difficult for you in terms of your health or your personal circumstances to avail yourself to travel the length and breadth of the country, if needs be, to hear cases?
Thank you, Judge Mir. There is no difficulty at all for me to travel throughout the country. As I disclosed in my application, that the RA that I'm living with is on remission. When it was acute, very acute, I mean, I could not walk, I could not write, but I traveled during the Fees Must Fall protests to represent the students, because I am known as an activist in the country. So I traveled to Cape Town. My base was in Cape Town. I traveled to Limpopo. I even traveled to Venda whilst I was still very sick. So I am able to drive myself now. There is no problem at all with regards to traveling.
One last question. You described yourself as an activist.
Yes.
Do you think being an activist judge can be problematic?
No, I don't think so. I don't think so because the activists, as I know them, they are the ones that are balancing the rights well and are not afraid to go to where others are afraid to go. So I think all of us should be activists all of us should be activists, especially then in the land claims court, where you are dealing with the most vulnerable and the most privileged. So in terms of balancing their rights, I think my background of being an activist is going to assist a lot in the land claims court.
Thank you. No further questions.
JB? Oh, thank you so much. I'm sorry, I just got distracted for a minute. JP Mlambo?
Thank you very much, DCJ. Good morning, Ms. Flatela.
Good morning, JP.
I was a bit worried when the DCJ was talking to you about the challenges you had in delivering those judgments. I was worried that you were not going to disclose that we actually did speak afterwards.
No, not like that, JP. I had
Yeah.
disclosed, yes.
Yeah, but I think I just want this commission to know you were not, what I told you was you should have spoken at the time, because as part of my support for women to come to the bench, especially those who run practices, I understand the challenges they have. And that's what I told you, you
Yes.
remember?
Yes,
To say
you
you
told
should
me.
have spoken earlier so that one knows what challenges you have and what support structures one can put, or what sort of leeway can be given to you for you to hand down those judgments. You confirm that discussion?
I confirm that discussion, JP.
Yeah. But other than those judgments in that period, you've not had occasion to reserve more than beyond 3 months. Am I correct?
Yes, yes, JP.
Okay. And you regard yourself as ready?
I am ready, JP.
Yes. Thank you. Thank you, DCJ.
Thank you, JP. MEC Mamabolo, are you available on the virtual platform?
Yes, good morning. I am available, but at this point, I don't have any questions. But I am here. Yes, thank you.
Thank you, thank you. Commissioners, do you have questions? Minister, go ahead.
Thank you. Good morning, Mr. Flatela.
Good morning, Minister.
Yeah, mine relates to the fact that for sure you know there is a land court bill now in Parliament. What do you see as your role going forward in expediting the matters that they've been clogging the court role in the land claims court as soon as you are appointed and as when the bill become an act?
Thank you, Minister. I hope the land court is going to be established very soon, because as you correctly state, there is a backlog in the land claims court. What I have known, what I've learned in the Gauteng division about the case management flow. They have a comprehensive case management flow. I should think if the land court adopts that or create that, it is going to be very effective. For instance, the land court comes at the land claims court come at the very end of the process, because the processes are the commissioner, the commission, the office of the commission. It has enormous responsibility from assisting the claimants in filling or in completing the land claims to the negotiations and mediations. So the Land Claims Court comes very late when they certify that it is not feasible for the matters to be resolved. Then it is then that the matters are sent to court for adjudication. So once those matters are sent to court for adjudication, once the judges are allocated the matters, that is when the cash flow management should start to follow up on the matters that must be dealt with, to follow up with the Commissioner's Office and the participating parties. That in that way, it is going to be easy to deal with the matters and to have matters heard and to decide on the matters.
Yeah, my second question relates to the Tobejan and others versus the Regional Land Claims Commissioner.
Yes.
It looks like it's a matter you presided on, and you have seen the comment of the GCP.
Yes, yes.
So what worries me there is that our expectation is that the land court should help develop jurisprudence in this field of the law. So their concern there is that your judgment did not explain adequately why the relief that was not sought was granted, and why the parties did not appear to have been provided an opportunity to make submissions. What is your view to that and into your ability to help develop well-reasoned judgments?
Yes, I think there's the first judgment. The matter came before me as a review of the decision of the Commission to publicize the land claim in the Government Gazette. So during and it came, issues were convoluted and all that. So during the course of my consideration of the matter, I found that there are other documents that I would like to have sight on, and the Land Claims Court as a court of equity were allowed to call for further documents in order to make a good judgment. So I called for the file from the office of from the office of the Commissioner, because they had attached the extracts from the file, and their course of action was based on that extract. So I needed the whole file to find out what really happened. So that is what happened. So I issued that as a rule NISA, and it was done, and that was I was able then to deal with the matter thereafter.
Thank you, DCJ.
Thank you, Minister. Commissioner Matoro Lepu.
Thank you, Deputy Chief Justice. Good morning.
Good morning, Mam Tlep.
How are you?
I'm fine, thanks, Mam Tlep.
Okay, what I just wanted to say is that I really allowed you for really taking up, making yourself available for the land claims. As you know that the legal aid is now in charge of legal aid matters. We've been trying to train a lot of female advocates, young female advocates, to take up land claims matters. But one of the things that discourages us is the issues of the Lamusa judgment. I think somehow it stagnated the matters for going forward. What is your take on that?
The Lamusa judgment deals with the reopening of the land claims. And then, according to that judgment, the Parliament was given time to deal with the Act, so that it is within it passes constitutional matter. Unfortunately, the Parliament failed to do that. So all those claims are now freezed. So that is the status quo of the matter.
Just for up, will you make yourself available to train the women advocates and attorneys that I'm talking about?
Yes, you know, I have, during the time when I was a state attorney, and even as a director in my law firm, I brief women, black women advocates, and you know, and I have introduced many in the land rights matters. But the issue, Mamdlepe, really is the fees that are being offered to the claimants. Claimants are the most vulnerable. They are the most oppressed, most degraded. If you want to see the apartheid life, you look at the lives of the farm dwellers and farm workers. But you find that the government, in supporting them, the rates that the advocates and attorneys are paid, it's an outcry. Yet their own advocates are paid the rates that are in line with the. So that is why you will find few or less qualified people that will take up the claimants' cases. Yet the claimants' cases are highly defended. The landowners, they defend, they are well resourced, and they defend those claims. So it's like it's as others that had agreed to the rates, because I would disclose the rates, they would say we take it as a pro bono. You know, I'll just take it as a pro bono, as a service to my people, but the rates are really not fair for the claimants, because they are not getting the best legal representation due to the rates that are being paid.
Thank you so much.
Thank you, Commissioner Klepu. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good morning, Flatela.
Good morning, Dada.
Just one question from my side, which is informed by the latest land court bill that was passed by Parliament. Do you think the proposal to establish a specialist land court with its judgment appealable by the full bench of that court will help to deal with all land-related matters as regulated? Thank you.
Yes, I had a look and considered the land court bill. With regards to that, my only worry was the resources, whether the government is going to be able to establish that court. I thought to make things easy, I thought putting land court under the high courts, like we have tax courts that are accommodated in the high courts, and for access also, you know, because if the land court is going to deal with all land matters, not only land claims matters, the High Court, for instance, if you look at the PI jurisprudence, they have been dealing with these land matters, except those that are exclusively the restitution of land rights, land rights. So I thought the High Court is in a position, because High Courts are already been established, they are there, and even in they can lend some judges also to deal with these land matters, because they are, it's really an issue that is pressing. High Courts are dealing with land matters every day, and I must say the eviction jurisprudence has evolved and is solid, you know, compared to Esther jurisprudence. So I thought that would help. But yes, if the government's vision is to have the land jurisprudence, then it is a good move that we have the land court and the land appeal court, because the judgments currently you can only appeal in the Supreme Court of Appeal. So it takes a long time, you know, for the parties to get justice.
Thank you, Ms. Flatela. Thank you, Deputy Chief Justice.
Thank you, Commissioner. Commissioner Marumachai?
Thank you very much, DCJ. Good morning.
Good morning.
I wanted to ask you one question, but your response to the previous question led me to another question that triggered my mind. When you say PI is solid, I'm not sure. Are you aware of the recent Constitutional Court case, the Grobler versus Phillips?
Yes.
You're aware of that judgment?
Yes.
In that judgment, I just want to hear what your views are, because it appears that the Constitutional Court in that case was faced with the rights of the old woman who was sought to be evicted, and the owner who wanted to buy the property to build houses for his old parents. And then it crafted a judgment, a very generous judgment, placing the onus on the owner to provide alternative accommodation and not on the state. In light of that judgment and the reasoning, do you still hold the view that PI is as solid as you said?
At least, you know, Commissioner, the issue, the really primary issue is the lack, is landlessness. You know, the old woman that was staying there with, he claimed that he had lifetime right to stay in the property, and Mr. Phillips offered to buy him her property and all that. The issue is landlessness, and when you don't have a solid laws that protect people without land, so it becomes very difficult, you know, to enforce the rights of an occupier as against the rights of the landowner. The test there is you can evict if it's just and equitable. So when Mr. Phillips, if Mr. Phillips offered that accommodation, then it was regarded as just and equitable. Then there was no way that the Constitutional Court would say she must stay in the property.
No, thank you very much for that. The second question that I have for you is in relation to, because you authored a judgment which, but I'm more interested in the appeal judgment that you did, the Mahlangu versus
Mahlangu.
Duplessis. And I thought it was a very progressive one, but it showed the tension, right, in South Africa in terms of religion and our cultures in those rural areas and the level of intolerance. And I thought it was a very positive judgment. But what I want to get from you is, do you feel that the law generally, and Esther in particular, is doing enough for people who are residing in farms, given some of the challenges that they are experiencing? Some are evicted, some they have to leave their graves, and all those things. Do you think the law in particular, the law generally, and Esther in particular, is adequate in assisting those people who find themselves in unfortunate circumstances?
No, I don't think so. I think Esther's jurisprudence is shaky when it comes to, although it's meant to assist those who do not have legal land tenure. But at the end of the day, the laws, there is no, except the restitution and the Labor Tenants Act, that at least gives land to the labor tenants if they are declared labor tenants. With regards to the occupiers and farm dwellers who stayed so many years in the farms, they despite Esther, they don't have law that is protecting them against inevitable the eviction.
Thank you very much. Thank you very much, DCJ.
Thank you, Commissioner Magai. Commissioners on the virtual platform, do you have any questions for the candidate?
Good morning, Deputy Chief Justice. It's Glynis Arju, please.
Good morning, Ms. Bredenbach. Do you have a question for the candidate?
I do, thank you.
Oh, please go ahead.
Thank you. Good morning, madam.
Good morning, Council.
I'm assuming from the questions of the Minister that you're familiar with the Land Court Bill.
Yes.
I'd like to hear your views on the importance or not of the fact that the court will be a court of law and equity for limited purposes. Just your view on the equity portion thereof, please.
Sorry, Commissioner, I did not hear you. I think you fast.
Okay, sorry. The bill will have a limited applicability as a court of law and equity. I'd like your views on that limited application of a court of law and equity, the importance thereof, please.
Yes. In this case, in the land matters, it is important that the courts that deals with land matters be the court of equity, in that the laws that were enacted by the previous governments, you know, dispossessing people of the land and excluding them from economic, from land and from mines, so those people that have been excluded by laws has to be protected, are now protected by the Constitution. Now, when you deal with the matters, you have to consider their rights, the human rights, and you have to, in interpreting the law, you have to take consideration of the history, because if we are, we are saying the Constitution is our document, is our law to achieve equality, dignity, and all. We should, the courts should have regards to the history in order to interpret, in order to grant those people fair hearing. So equity, I support that the courts that deals with the land matters, especially restitution matters and landlessness matters, they must be the court of equity rather than
Thank you.
adversarial.
Thank you.
Thank you, Commissioner Bredenbach. Any more
Deputy
questions
Chief
from the
Justice.
virtual platform? Welcome, Commissioner Singh.
Good morning. Thank you very much, Deputy Chief Justice, and good morning to all the commissioners and our staff that are there, and good morning to Ms. Flatela.
Good morning, Mr. Singh.
Good morning. May I proceed with my question, Deputy Chief Justice?
Yes, please.
Yeah, thank you very much. Ms. Flatela, in Parliament, well, in the last year or 2 years or so, we've been dealing with the question of amendment to the Constitution, Section 25. And you would know that we didn't receive the 2/3 for an amendment to the Constitution. But of late, we've had the expropriation bill come through Parliament, which received a simple majority for it to proceed to the NCOP. What difference do you see in the intention of the Section 25 amendment to the Constitution vis-a-vis the intention of this expropriation bill that has received a simple majority in the National Assembly? That's my first question. Thank you.
Yes, you're asking the intention of the bill. The issue, Mr. Singh, is the primary issue in all this. It's I think when we got freedom, you know, we ignored the part of the land and landlessness, and now we are dealing with secondary issues because we realized after some time that there is no land available for the majority of people here. So now we're trying to use expropriation and all that to address the issue of landlessness. But I should think the issue of the amendment of the Constitution, I don't think there is a need to amend the Constitution to deal with the expropriation. Even the 25(3) was not tested in our courts. So I do think that, or it's my view that the government should be willing to deal with the issue of the land, and whether it's through that expropriation, the jury is still out. We'll see if the government is going to be able to expropriate land, because even in the presence of 25(3), there is no. I don't remember that there is any matter that has been tested in court regarding expropriation.
Okay, thank you for that. My second question would relate to PI, and the Professor Commissioner asked about PI and its intentions. And there again, I think it's a very good act because it prevents illegal eviction of farm workers and destruction of graves, etc. But here too, of late, we found that in urban areas, there are people that are illegally occupying homes, which are registered in the names of individuals, and they try and hide behind PI. And I think that becomes quite a dilemma. So do you think there may be need to re-look at the PI Act to ensure that these unscrupulous occupiers, illegal occupiers of homes that just come in to take over a home, it could be your home, it could be my home, it could be any of the commissioners' homes in an urban area, try and hide behind the PI Act?
Yes, yes, Commissioner Singh, as I said, I think the primary issue is landlessness. People would not just go and occupy people's home. I think it's out of desperation of not having alternatives. But then the PI does not say, does not give rights to take over the home. But in the event of eviction, the Act states that the rights of the people, because they are the people, they have the same equal rights, must be protected. Because eventually, PI does not take away the rights of owners in terms of Section 25(1). It just makes it making sure that the rights of the occupiers are protected.
Thank you very much, Mr. Flatela. Thank you very much, Deputy Chief Justice. Good to be back. Thank you.
Yeah, we're glad to have you back too. We've missed you. Commissioner Ngqoito, you sure you want to ask a question?
No, DCJ, I'm holding myself. Thank you for making yourself available, Acting Judge Flatela. I'm very pleased that you are here, and I would have asked you one question, but I think I probably should not.
Thank you, Counsel. Yeah, you should not. I know where you're going to.
In your application form, you disclose that you suffer from a certain medical condition, which is, however, in remission and does not affect the quality of your work. But one of the professional bodies has asked that we find out from you anyway if you will be able to withstand the rigors of judicial office if you are appointed.
Yes, thank you, DCJ. Yes, I live with rheumatoid arthritis. I'm not afraid to disclose that because it's an autoimmune disease, but it is on remission, as I say. The living with RA is not a problem. As I said, the matters that I dealt with when in my firm, when it was still acute, and the matters that I am known for, I dealt with them when I was really, really sick, you see. So it's not a problem. The issue is support, is support system that I should think I must state that one needs support in terms of your functioning PAs or secretary, I don't know, you have secretaries or PA, and pairs the research assistant that will be available when she or he is needed.
Did it adversely affect your work output at all when you were acting as a judge?
No, DCJ, as I disclosed earlier, that what affected my work outputs is not having a support system, because my PAs and my interns were affected by COVID, and I had to, most of the time I had to be alone and do things and deal with the workload, which was too much. Too much to do by myself without any support. I employed new people, but it is difficult when you have to teach those people. But yes, that is what I would put out there.
All right. Thank you so much. Well, it does not appear that there are any more questions for you. Thank you for making yourself available for this interview.
Thank you,
And
Secretary.
unless you want to say anything more to us, you're free to go.
No, I think I've
You
my
can't
work
wait
speaks
to leave.
my work speaks for itself. So,
Okay.
yes.
Thank you so much. You're excused.
Thank you.